Section 2B, which the lawyer Dan LeBlanc has brought up, includes freedom of the press, but it also includes freedom of expression, or just free speech rights. And so essentially his argument is that there's an interference with freedom of expression by the government having taken, or the police having taken enforcement steps against the activity here. The argument is that there's expression because there's a meaning conveyed about political issues by the presence of the protest, and the courts do take expression very broadly. So there would be an expression issue raised. The real issue is going to end up being whether it's a permissible limit on expression for the government or the police to have taken enforcement steps in relation to the bylaws on the use of parks. And I guess the question there probably hinges on whether it was a bona fide or real arrest for purposes of enforcing the law, or whether it was being used to exert pressure on them to take down the camp. And if they could prove that it was used in not a genuine way, just to exert pressure, that probably would make out a constitutional issue. It's just, I suspect the police can probably make a fairly good argument that they were just enforcing the law. But that will be something to be tested by the court and to sort out on the facts of the case. When there's a freedom of expression issue raised, the question is, has there been a reasonable limit put on that freedom of expression? And the closest analogy I could come up with would actually be that there were some cases about the Occupy protests a few years ago when there were also people who stayed in parks overnight as part of a political message. And those were litigated in some different cases, particularly in Toronto and Vancouver. Some of the cases came out different ways. Well, what's really at issue is there a reasonable limit on freedom of expression that's been imposed for purposes of having the park or the legislature? Issues around if the government limits the content of expression, especially if political expression, that immediately becomes something that's pretty easily challenged. Here what they're doing is limiting the place of expression, and there's some complicated case law around that, and the courts will have to sort through this as to how that comes out in light of that law and in light of the facts. But there's no absolute priority one way or the other. They're really getting into a balancing analysis. And essentially where there's a statute or a law passed for some legitimate government reason, and that could include something like the use of a park, then there's a testing process and some particular tests that the court goes through in deciding whether this particular restriction is a reasonable limit or is not a reasonable limit in light of its effects on freedom of expression. So if there were a charter right that were clearly infringed and it weren't a reasonable limit, it of course takes priority, but the government can pass laws that limit charter rights in light of other government objectives, and the question for the court in this case will be if that's what applies here or not.